Section 2.3 is fairly lengthy, so I wanted to break this video up into two parts. This is the second part. As I mentioned previously, there's significant content you should be taking note of that goes into the details of some of the following. The pith and substance rule, the Canadian Charter of Rights and Freedoms, the amending formula, the general formula, and other amending formulas. This knowledge and understanding serves as a foundation for understanding the Canadian Constitution's impact on Canadian society. How has the Charter influenced federal and provincial governments? You may have heard people say or claim that some action by the government is a violation of their charter rights. This is a situation where judicial decisions look at the charter rights contained within the Charter of Rights and Freedoms and determine whether or not a certain piece of Canadian legislation or an agent of the state, which we'll take a look at next, actually violates an individual's charter rights. There are a number of cases that are discussed, and they're listed in the section. One of them is polygamy, that is marrying more than one person at the same time. Freedom of expression, freedom of speech, but expression is a broader term, and also various criminal law cases. As I mentioned before, the question is also asked, has the Charter influenced the work of government agents? In this case, maybe the police, or CSIS, the Canadian Spy Agency, border officials, or other government agencies. Has the fact that we have moved from legislative superiority to constitutional superiority changed the way they are able to do their jobs, and whether or not their actions violate your or somebody else's charter rights? I understand that that's a lot of reading, but you should be able to condense in your notes so you can quickly understand which powers are held by which level of government, what your rights and freedoms are, and so you will more easily be able to go through an inquiry process. So use your legal studies organizer to analyze the cases, determine from the information and evidence you've been given what the key and important points of the case are, the relevant legal concepts, the legal significance, and what is the change in law that is taking place or being asked to take place. What are the interrelationships that are being affected by the law as seen in the case? An interesting question that I'd like you to participate in is a discussion format that's asked for in Section 2.3, and that's whether or not judges should or should not be elected. Currently, judges are appointed by a provincial or federal party who forms government. This question is asked because we must trust and believe that judges should be entirely independent of political opinion in their judgments. They should be obeying the Constitution and the Charter. They should not be nonpartisan. They shouldn't be liberal or conservative or NDP or Green or whatever political party is out there. Rather, the foundation of this course is that justices should be just, and rather they should be following the law and the principles that we've been discussing and without considering political implications or being pressured by political parties. But if judges, being human and being subject to human frailties, are being appointed by those in political power, it just might be too easy to see how those judges could be the friends of those in political power, or could be leveraged by those in political power. There are pluses and minuses to having judges being elected by people or being appointed by legislatures. So in general, Canadian judges are not elected. They are appointed. In the United States, some judges are appointed and some are elected. It's quite different, again, down there. Don't mix up the two. I won't be asking you for any information about the United States, but sometimes because they are a big country directly to the south of us, and we often see a lot of U.S. television. And there are references to American legal processes in that television sometimes. Sometimes we can get confused about what Canadian law actually is. So in the consolidation section in 2.3, a key concept is explored, and that is constitutional supremacy. Since the Charter became part of the Canadian Constitution, the notion of parliamentary supremacy, that is, the elected leaders get to make whatever laws they want, and our votes were able to remove them if we feel they were on the wrong track, has been done away with. We now have a constitutional democracy with constitutional supremacy, whereby the government just can't make any law it wants. For a law to be truly legal in Canada, it needs to not violate Charter principles. It needs to be consistent with the Canadian Constitution. Thank you for listening.